moving through. So turn now to Noel, item 4A. On the agenda. Well,
Yeah, we can Judge Keith. I am going to be talking for a bit, if you
Okay.
allow it.
please.
We have a bunch to go through. I'd love to just orient us all on where we are, how we got here. So big picture is that the commission is subject to the Open Meetings Act and the Open Records Act. We're subject to the Open Meetings Act by the express terms of that statute and by our own bylaws. We acknowledge that. The commission is subject to the Open Records Act by the terms of that statute, although the commission's bylaws are silent about the Open Records Act. So the Open Meetings Act and Open Records Act both provide for criminal and civil penalties for non-compliance, and actions for civil penalties may be brought by private citizens. So background on recording meetings. Staff has always recorded meetings to assist in preparing minutes and to determine all action items flowing from a particular meeting. So prior to the pandemic, we held meetings in person with a dial-in option and only had audio recordings. With the pivot to Zoom brought on by the pandemic, we have the novel issue of people requesting recordings of meetings, and that's never really happened before. So over the last year or so, we've randomly but routinely been asked by members of the public if we can provide them with a recording of the meeting. Typically, this happens orally during the meeting itself. You may recall during the commission meeting back in August that occurred. In response to that and similar requests, I have continued to maintain that we comply with the Open Meetings Act, which requires that we produce 4 documents for each meeting. Those are a meeting notice, a meeting agenda, a meeting summary, which must be posted within 48 hours of the meeting, and then the full meeting minutes once approved. So during the 8/19 meeting back in August, I believe that you appeared not to oppose offering recordings to the public, but you didn't want to obligate commission staff who are employed by the Judicial Council's Administrative Office of the Court to do something that we were incapable of doing, like logistically. Also, at the close of the meeting, one of our commission members, Regina Quick, raised with me whether the oral request for a recording could be considered an Open Records Act request, because I had treated it only as an Open Meetings Act issue. So because we were in a meeting setting, I'd always thought of requests for recordings of meetings as calling for legal analysis under the Open Meetings Act. But I think Regina is right in that an analysis under the Open Records Act is also warranted. So I delved into it, and that's a nice way of saying it. I was really like, holy mother of Moses. What? Wow. Okay. So let's just say I've delved into it. So let's go through the Open Records Act analysis. So Georgia has a very strong public policy in favor of open government and access to public records. And we have what are colloquially called sunshine laws. We specifically call them our Open Meetings Act, Open Records Act. By my analysis, the Open Records Act request for a meeting recording would need to be honored because those recordings qualify as records, and you are putting those records in the ordinary system. And I don't think they fall under any of the 48 exceptions provided by the Act. So records that exist at the time they are requested by the public are required to be disclosed, which led me to delve into the state's records retention policy. So because we use the recordings only to create the approved minutes, the state's records retention policy does not require us to keep those recordings past the approval of the official minutes. But here's a caveat. During that period from when the recording is made to the approval of the minutes, the recordings would need to be produced because they are in existence. So that's by my analysis. And most requests do come in during live meetings. Open Records Act expressly states that requests may be made orally. It also requires a very quick response time of 3 days. Running recordings to individuals via email, I fear would be difficult. These are large video files and would create us independently responding to each requester. So I just want to discuss how many meetings we're talking about. In 2022, To date, including this meeting, we've held 16 meetings and 4 to 5 more are slated for a likely total of approximately 20 meetings in 2022. And in 2021, we held 21 meetings. And by meetings, I'm not just full commission meetings, all subcommittee meetings, study committee meetings, work group meetings, anything are equally subject to those acts. So we have to do all 4 of those documents for every single meeting. All right. There is some sensitivity. I want us to acknowledge an incident we had. There's some sensitivity around recordings because about a year ago or so, a private party independently recorded a meeting, a parenting time deviation study committee meeting. They further edited that meeting to show Katie Connell in an unflattering light. It was unkind, and it was posted to Twitter and tagged the Judicial Council's Twitter account. So that's how I became aware of it. So I just want to acknowledge the sensitivity around recordings. Okay, I am almost done.
Okay.
No, good information.
As part of my delving, I convened an internal Judicial Council AOC meeting back in mid-September to just come to consensus on what we could do logistically, with the question being, how could we comply with the Open Records Act to efficiently and economically provide recordings? At that meeting were Jessica Vera, our general counsel, Billy Scott from our legal department, Ben Luke, our IT division director, Michelle Barkley, our communications director, Elaine, Latana, and myself. Okay. So unanimous consensus was to start posting the videos as a matter of course in the least onerous way possible, suggesting that we follow the method used by the Judicial Council of Georgia, which is to live stream meetings from Zoom directly to YouTube where they would remain. That's what the Judicial Council currently does. So that would mean making a newly created Child Support Commission YouTube channel where we could post videos. This would automatically, that would take a little setup before each meeting, but this would be seamlessly live streamed and then permanently or reside on a YouTube channel. Also, if something went awry with the live stream, we could manually post a recording of the meeting after the meeting. A link to those videos could also be put on the commission's website, so it could be found in 2 places if we wanted to. That would be yet another thing for us to do, but it's possible. So this would automate how videos get posted and allow for convenient public access without staff needing to individually email people who request recordings. Eventually, the public would become accustomed to go directly to the YouTube channel for recordings without the need to request them. I am concerned about the inefficiency of individually emailing recordings. These are large video files. Our meetings are typically 1.5 to 2 hours. So going forward, it's clear to me that we need to comply with the Open Records Act for recordings of meetings. The question is what method we use to do that. Questions remain, do we need to seek further guidance on my Open Records Act analysis? Do we adopt the JCAOC's recommendation to provide recordings of the meetings via a Child Support Commission YouTube channel? If so, how long do they remain on the YouTube channel? By law, we could destroy all recordings after meeting minutes are approved. Personally, I'd hate to see those recordings deleted because we know that people are already independently recording meetings. The Open Meetings Act actually expressly permits people to record. That would mean that recordings of commission meetings would be out there, but we wouldn't have a recording of our own meeting. So especially because of the risk of people editing and manipulating those meetings or those videos, which has unfortunately already happened, I do think there is value in keeping an official record. In other words, in us keeping recordings of our own meetings.
Is there a record retention policy which you're required to comply generally?
I think there is, but it's been recently modified. We talked about that.
Yeah, I was just on the state archive. The state archives is the entity charged with I don't know what the word is, the records retention. I just went in and specifically, I would have to look it up for each type of record, but I specifically looked it up for recordings, and it really depends on what the recording is being used. So we never go back and really use it for anything else. It truly was just an internal aid to make sure that we're not dropping the ball on anything to help us create the minutes. But we do keep them. We don't delete them. So if we have them, they need to be produced.
So, questions from commissioners? Questions or comments?
This is Roger. So we expect that, first off, did the AG's office weigh in?
That is something I could pursue. I have not yet contacted the AG's office.
Because it would seem to me we would seem like we wouldn't be in a position of taking some position counter to what the Attorney General's office says, number one. Then number two, I assume we have adopted this policy, we would have a live date at which the policy kicks in from that point forward. And then the third comment would be we would need to be very, and this really would fall upon Judge Key, I think we'd have to remind all of our public comment section about this availability, because we try very hard to prevent people from trying to relitigate their case in the public comments. And I would hate to see them say things on the recording that come back to adversely affect them or other parties in subsequent litigation.
Thank you. Other comments or questions? Other thoughts I have. Number one is we need to make sure we're complying with the law now, which means we record and we make it available upon proper request. And we can defer questions around retention and how to post it until you consult the Attorney General if you choose to do that. The directive going forward is we will record, and unless we have some other acceptable way to do it, in the meantime, we need to provide it basically upon proper request. Work as quickly as we can to get something more efficient in place. Sound reasonable to everyone?
Yes, indeed. As you know, both the courts and the AJC are very, very tuned in to anything that they can either is or they want to whip into believing there is some intentional violation of circumvention of open records. So I always err on the side of making as much available as you can. I do have some privacy concerns, but I guess if somebody's willing and they know they're being videotaped and recorded, you know, I don't know if any precautions, and again, the AG's office can lead on that. We're all going to be on it. So I guess if a witness is there, then they realize that their face is going to be on it too.
We can certainly build into our opening comments appropriate notification about the recording and its availability to the public.
I think it would be worth saying it again right before the public comments.
Again, just weighing in unless someone else wants to as well. I want to do it in the way that meets the legal requirements, but is the least burdensome on staff. And it sounds to me, since the Judicial Council is already doing it, that would be the YouTube channel. I guess actually proving that to the extent we do need to prove that could await the next meeting, as long as we're in the meantime we're complying.
Yeah, in the meantime, we would comply on an individual basis. Obviously, like we're not going to set up the YouTube channel or anything like that. I will, but I'm hearing that everybody wants to and reach out to the AG's office to get an additional opinion.
Judge, I'd just go maybe one step further and say that if the AG weighs in and it's consistent with what we've been discussing, whether it needs to be circulated by consent minutes for a vote, e-vote or otherwise, I would want staff to not wait till our next meeting to go ahead and create the YouTube channel and post the videos so that would relieve them from the burden and stress of zip drives or whatever other technology that I'm too illiterate to know about exists to help them comply. So
let's try to flesh that out into a motion then if we can to approve it. One is that subject to the AG's approval, that we record all meetings, we make them available to the public through YouTube, and that the YouTube videos be made available in accordance with this, the applicable retention policy. So generally, records have to be retained for 3 years or 5 years or 7 years. This is a record and would need to be retained for the same period. Anything else that would need to be in that motion? Staff, are you guys good with that? Your
Is that a motion? Is that a motion, Judge? If it is, I'll second.
I have a motion by Regina and a second by Chuck. Any further discussion? All in favor, say aye.
Aye.
Opposed, say nay. Any nays? Any nays? Any abstentions? Motion carries. Thank you, Regina.
Yes.
If you will, at such point as it is approved, notify the necessary. You want to document that more completely in the next meeting. Thank you.